Do I qualify for an annulment? Dustin McCrary, divorce attorney and founder of the law office of Dustin McCrary, discusses certain situations which may qualify for an annulment under North Carolina law. Hi, I'm Dustin McCrary. Thanks for joining me today. Today, I'd like to answer a question that comes up more commonly than most people might realize, and it's, can I get an annulment? Some of us have heard about annulments in the media. Famous couples who may have gotten married after one too many drinks on a night out and a week later announced that the marriage has been annulled. I'd wager that very few of us actually know someone that's had a marriage annulled, and that's because in North Carolina there are very limited circumstances under which an annulment is even possible. Before we talk about those limited circumstances, let me be clear on what an annulment is not. It's not something that can be obtained because two people get married and later decide that it wasn't a great idea. It can't be obtained because you simply fell out of love. That's true whether you've been married for a few months, a few years, or many years. All of us have gone down paths that we later decide perhaps weren't the right path for us. And while hindsight is 20/20, it doesn't legally qualify you for an annulment. So if we know when an annulment is not, when is it? In legal terms, annulment is a procedure that declares the marriage null and void. It means the marriage is considered invalid from the very beginning, almost as if it had never taken place. It essentially cancels the marriage, declaring that it technically never existed and was never valid. This is different than a divorce, in which the marriage and the validity of the marriage is recognized, but the parties both express an intent to return to being single. What conditions qualify for an annulment? First, if one of the parties lacks the mental capacity to understand the marriage, an annulment may be a possibility. If, for example, it can be shown that one party to the marriage is not mentally competent and incapable of making a rational decision, then an annulment is a possibility. If it can be established that one of the parties was underage when the marriage occurred, this may also qualify for an annulment, as would a situation in which the parties were married under false pretenses. For example, if one party lied to the other about being pregnant. Another condition that might qualify is if one of the parties is impotent, and that was the case from the beginning of the marriage, and the marriage was never able to be consummated. If that can be established, then an annulment will typically be granted. Finally, if it can be established that the parties who entered into the marriage are too closely related to one another, for example, they're siblings or first cousins, an annulment may be allowed. I'm often asked about bigamous marriages, that is, any marriage in which one party is already married to someone else when the marriage takes place. If this is your circumstance, you will not actually need an annulment because you'll really not be considered married at all. In this situation, as one party is already married, the second marriage is considered never to have occurred at all, and an annulment is not even necessary. These are the main instances in which annulments are granted, but it's important to remember that in the majority of instances, an annulment will not be granted, and parties will need to pursue the traditional divorce route. If you're contemplating divorce and need legal assistance, I'm here for you. I'd welcome the opportunity to talk to you at any time and learn your story and find out how I may be of assistance. I look forward to speaking with you soon.